Today's case is a roller coaster of legal patience, pink eye excuses, and a defendant who may or may not speak English fluently, depending on the moment. On one side, we've got a judge determined to cut through the delays and get to a resolution. On the other, a defendant whose courtroom strategy seems to shift with each hearing, sometimes needing an interpreter, sometimes answering perfectly in English. What's at stake? Restitution in the thousands, potential jail time, and yes, possible immigration consequences. But as we'll see, the real tension is whether this case finally reaches a verdict, or gets pushed off yet again. Let's dive in.
He's always got an excuse, it seems like. I know. Well, you understood what I said, didn't you? You just shook your head. Hey, you just shook your head when I spoke English. You understand English. Don't play with me. I'm not a toy. All right, this case been going on for a while. Your name? Okay. I'm ready to set it for trial. Does he want a jury trial or does he want a bench trial?
Here's where the judge's patience starts running thin. Multiple court dates, an interpreter for every appearance, and now pink eye. The judge points out this isn't a murder trial, for separate appearances have already chewed up court time and taxpayer money, not to mention interpreter costs at $160 an hour. This isn't just about one cracked side mirror, it's about the court's efficiency and fairness. Should defendants be allowed repeated delays for minor charges? Or is this exactly why the judge is laying down the law here? What do you think, is the court being fair or too strict?
Your Honor, it's my understanding that my client is now suffering from pink eye and he would like an adjournment.
Listen, I want you to tell him this. We try to provide fairness here. You don't get to bring interpreters into the courthouse every time you come here. I will also remind you that I was convinced by staff that you actually can speak English, but I'm doing everything I can to accommodate you with an interpreter. This is it. We've had too many court dates. This isn't a murder trial. You were here June 25th. You were here July 9th. You were here July 23rd. And now you're here August 6th. We are either setting this case for trial today or it's being resolved today. If you have such a bad condition of pink eye, you can go out in the parking lot and you can Zoom with your lawyer. I have no problem with that. If you called ahead, that's what I would have said. But I'm not going to keep adjourning this. These guys are charging a lot of money. And guess what? If there's a conviction, you're going to get to pay for it. So let's stop prolonging the case and either resolve it or go to trial. Period. You got it? I asked him if he understands.
I don't feel well.
Go out in the car. Go out in the car. If then we can just set it for a jury trial or a bench trial, as the case may be. I'm not going to keep. Taxpayers are not going to pay for these people to come in here. What do we get? $160 an hour, I think we're paying these interpreters. We're not doing this. So does he want a jury or a bench? I don't want to hear any more of your excuses.
Your Honor, can we recall this matter so I can talk to the client? I didn't even have to talk to him.
He's always got an excuse, it seems like.
I know.
Well, you understood what I said, didn't you? You just shook your head. Hey, you just shook your head when I spoke English. You understand English. Don't play with me. I'm not a toy. Now go out and we're either setting this for bench, we're setting it for jury, the prosecutor's dismissing it, or there's going to be some other form of resolution today. Period.
Thank you, Your Honor.
Thank you.
So state your name for the record.
If there's restitution, there's no civil liability, really, right? I'm not gonna take a no contest plea. It's either going to have to be a guilty plea, and that's fine. Attempt MDOP, but when there's a some certain, that's not going to fly with the civil liability.
Well, part of the rationale, there are some concerns about his citizenship status and providing a record that could somehow undermine that status. So
Now we hit the legal meat, the difference between a guilty plea and a no contest plea. The defense wants no contest to protect the defendant's immigration status. The judge, not having it. Why? Because with agreed restitution, civil liability is essentially off the table. In other words, there's no separate lawsuit risks, so a no contest plea doesn't make sense here. This is a great example of how judges think about consistency. If they make an exception for one person, they might have to do it for everyone. Here's a question: should immigration consequences influence how judges accept pleas?
ability concerns there.
I just can't. I don't want to treat people different. I think I'm treating them different. I don't.
Well, then let me talk to the prosecutors.
Well, why can't you just plead guilty? I don't understand.
Well,
You don't think immigration officials are going to look at it differently based on whether it's a guilty plea or a no contest plea, right?
we're concerned about it, providing testimony about his behavior, how that could play out in another circumstance.
Call in the prosecutor. Your name?
Good morning, Your Honor. Again, William York. I have to say,
So I really don't want to do these no contest pleas. I want to make sure that you guys have, gentlemen, I want to make sure I have your undivided attention here.
Sorry, Your Honor.
I don't really want to do no contest pleas when there's a sum certain, like there's no other cause of action other than repayment of the damage. So when we say civil liability and there's an agreement as to the amount of restitution, it doesn't make a lot of sense. So I'm explaining to them that I would take a plea to attempt.
Finally, after all the back and forth, the deal is clear. Plead guilty to attempted malicious destruction of property, get the main charge dismissed, and agree to $1,265.50 in restitution. That's a very specific number because it's tied to the exact cost of damage. This is a classic resolution in misdemeanor property cases. The court focuses on making the victim whole financially while reducing potential long-term consequences. But remember, while this plea avoids a trial, it still creates a criminal record, and for non-citizens, that can have big implications down the line.
MDOP, I don't have a problem with that, but it's going to have to be a guilty plea.
very well.
So does he want to proceed with that?
Can we recall, Your Honor? Just give me a moment.
Okay, sure.
Regional.
That's the problem, you know. If I do it for him, I got to do it for everybody else. That's the way I look at it. So I just can't justify that. So that's going to have to be it. Henry? All right. So now, as I understand it, it's going to be a plea of guilt to the charge of attempted malicious destruction of property,
Yeah, that's correct, Your Honor.
with the understanding that the malicious destruction of property will be dismissed and that there will be agreed upon restitution of $1,265.50 to the victim of the case, correct?
Correct, Your Honor.
The judge now lays out the maximum penalties: $250 in fines, up to 45 days in jail, plus court costs. Notice the emphasis. These are maximums, not guarantees. Many defendants panic when they hear this, thinking jail time is inevitable, but sentencing depends on factors like criminal history, cooperation, and whether restitution is paid quickly. The defendant even asks, "What can I do to avoid jail?" A moment that shows how high the stakes feel, even in a relatively case. What would you do here? Take the plea and hope for leniency, or risk a trial?
Do you understand that?
Yes.
Do you agree to that?
Yes.
Did the interpreter explain the advice of rights and cover all these with you?
Yes.
Did you read them and understand them? Did he read them to you and did you understand them?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Está cediendo todo su derecho y no va a haber juicio. Yes.
To the charge, attempted malicious destruction of property, how do you plead?
¿Cómo se declara?
Sir, you'll be pleading guilty today?
How do you plead to attempted malicious destruction of property?
Intento de destrucción maliciosa de propiedad, ¿cómo se declara? Guilty.
Which, by the way, you understand the possible penalties, correct? Up to $250 in fines, 45 days jail. Court costs are all of those. You understand that?
Could you repeat that, please?
The possible penalties, the maximums, these are the maximums, up to $250 in fines, 45 days jail. Court costs are all those. Do you understand that?
So is that, would that be all of those or just one?
It can be all. Those are the maximums.
When will that be defined?
At the sentencing.
What could I do to avoid jail? What could help avoid jail?
I didn't say I'm sending you to jail. I'm going to order a pre-sentence report. I don't know enough about you. I didn't say I'm sending you to jail. I just said that those are the maximums. I have to tell people what the maximums are. You understand that?
Yes.
All right. Knowing all that, you still wish to plead guilty.
Yes.
And you understand by pleading guilty, you're giving up all your rights.
Yes.
To the charge attempted malicious destruction of property, how do you plead? How do you plead, guilty or not guilty?
I thought it was attempted at the original.
Did I not say that? Did I misspeak? To the charge of attempted malicious destruction of property, how do you plead?
Guilty.
Were you at the Woodhaven Police Department on May 2nd of 25, located at 21869 West Road in Woodhaven?
Estaba en el departamento de policía de Woodhaven, municipio, esta dirección de I didn't know if that's where it was, but that seems like the right address.
Did you intentionally damage an individual's side view mirror
And here comes one of the more dramatic and slightly awkward moments. After insisting for multiple court dates that he needs an interpreter, the defendant suddenly answers in clear English. The judge immediately calls it out, pointing to, for prior hearings where this wasn't the case. Was this courtroom gamesmanship, or just a moment where frustration broke through a language barrier? Either way, it undermines the defense's earlier arguments and may have just shifted the judge's perception entirely. It's a reminder credibility is everything in court, and once it's questioned, it's hard to rebuild.
It was already damaged, but I think I did cause more damage to it.
How did you damage the side view mirror?
With my foot.
You kicked it, correct?
Yes, I fell.
Are you on probation or parole? You what?
What?
Can I say it? When I kicked it, I fell.
You intentionally kicked his side view mirror, right? True or false? Why are you suddenly speaking English?
Because I'm getting confused with him.
Anybody force you to plead guilty or promise anything to induce you to plead guilty? Anybody force you to plead guilty?
No.
And you understand, as a result of this plea, I'm not saying it's going to happen, but it could. There could be immigration consequences to this plea. Do you understand that? Or deportation consequences, I should say.
y eso se entiende eso, ¿verdad?
The judge now makes it crystal clear, pleading guilty can carry immigration consequences, including deportation. They stress that they don't know or want to know the defendant's status, but the law requires this warning. This is a critical safeguard if a defendant later claims they weren't told about the risk. The plea could be challenged. And here's the tough truth, sometimes a small criminal case in local court can have life-changing federal consequences. Should local judges weigh those risks more heavily, or is it their job to treat all cases by the same rules?
Could you repeat that, please?
Do you understand there could be consequences to this plea if you are not a legal? I don't know the status. I don't want to know your legal status. But you could potentially be deported. I'm not saying it's going to happen. You could potentially be deported as a result of this plea and conviction. Do you understand that?
Podría ser deportado o algún proceso migratorio debido a esa declaración y condenado. ¿Usted entiende eso?
You understand that, right?
¿Usted lo entiende, verdad?
Sí, pero no es un crimen de muerte.
Yeah, so, yes. Yes, but it's not a crime of moral turpitude.
All right. I'm not going to debate the law with you. I want to make sure you understand there could be consequences. Do you understand that?
Sí, yes.
Yes.
And you still wish to plead guilty?
Y quiere proseguir con la declaración culpable. Yes.
This is the United States of America. You do have choices. You just for the record stated in English, I have no other choice, even though you've been telling me for 4 court appearances you can't speak English. You speak English well. I don't know why you've been playing with us.
The problem is that
Just listen, I don't want to go into it. I just want you to know there could be potential consequences to your status. And as long as you're telling me yes and I still want to plead guilty, I'm taking the plea. If not, we'll set it for trial.
sí.
You still wish to plead guilty? I'll accept the plea. I think I still want a PS, and I'm dismissing the I'm dismissing the PSI. I'm sorry, dismissing the malicious destruction of property. I'm ordering a pre-sentence report. Tell probation we're sending them over. No contact with Carl Lucas. No contact with prosecution witnesses. No firearms. No weapons. And he did go over and get printed, right? Let me see here. Yes, he did. So we'll have a sentence date. Lisa, what can you do for me?
September 3rd at 8:30.
September 3rd at 8:30. Okay? So tell them they're coming over now. I wish you well. Thank you very much, Mr. Ward. Good luck, sir. Go down the hall, get your notice, go over to probation where you'll be interviewed. Thank you. Where's Jai Nolan at?
They didn't bring him.
So, where do we end up? A guilty plea to attempted malicious destruction of property, restitution of $1,265.50, no contact orders with the victim, and a sentencing date set. The bigger picture, this case shows how delays, language disputes, and plea negotiations can stretch even a straightforward property damage charge into months of legal wrangling. It's also a perfect example of how courtroom credibility and preparation can make or break a defense. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.